Hello, my name is Alice Collier, and I am the Senior Legal Research Associate for Agricultural Law Education Initiative, or ALEI. Today we'll talk about workers' compensation. This is the first part of a series of videos that ALEI will be conducting to provide our shareholders with legal resources they need. So let's get started. The first slide. All right. Workers' compensation is defined as an accidental personal injury that arises out of and in the course of employment. An accidental personal injury under workers' compensation must meet one of these factors. It can happen at your place of work or during the course of employment. It can be a negligent act by a third party, or it can be a disease or illness that arises out of employment. Or in other words, an occupational disease. Occupational diseases must happen as a result of employment and must cause the employee to be either permanently, partially, or totally incapacitated. A common example of this is asbestos. Let's go a little bit deeper into these definitions. For an injury to arise out of the course of employment, we will look at whether or not the injury occurred because of the conditions required on the job. So was it slippery? Was it a muddy surface? Was there ladders that hung up and something fell? Whatever the conditions of the job that helped cause that injury. And then we also look for when did the injury happen? It happened during the course of employment. So basically we're looking at the timing of the injury. So did the injury occur during a time period where the employee could reasonably be doing their job? Another important piece is who is covered. To be eligible for workers' comp benefits, you must be an individual that is under an express or implied contract with your employer. We'll talk more about this later, but basically, is there an employee-employer relationship that exists between the two parties? If there is, then workers' comp normally exists. But what isn't covered? What's not covered under workers' comp are injuries that are outside of the workplace. So injuries that are caused due to the influence of drugs or purposefully self-inflicted injuries are common examples. Continuing from the earlier slide, generally, like I mentioned earlier, when there is an employee-employer relationship, then workers' compensation also exists. So this can include family members, volunteers, or interns. In general, any employer with a payroll that exceeds 15,000 or has 3 or more employees is required to have workers' compensation insurance, regardless of familial ties. So if you have all family members that work for you, you still need workers' comp insurance. You have all interns or volunteers, you still need workers' comp, because there is an employee-employer relationship, and you most likely do have a payroll of 15,000. Or if you don't, you have multiple employers. So you still need workers' comp. And because of these relationships, whether they're familiar relationships, interns, volunteers, it does not change the benefits that are received. So the benefits do not change because of the employer's title. The benefits are determined due to the nature of the injury, the severity of the injury, and the cost to recover from it. So we mentioned family members, we mentioned interns, we mentioned volunteers. What about undocumented workers? Are undocumented workers covered under workers' compensation? And unequivocally, the answer is yes. Once again, is there an employee-employer relationship? For undocumented workers, there are for most of them, if not all relationships. So workers' compensation is still needed. The next slide. How to obtain insurance coverage. So employees in the state of Maryland are required to obtain workers' compensation insurance from any insurance company licensed to write workers' compensation insurance in the state of Maryland, or from the Chesapeake Employers Insurance Company. Employers may also apply to become a self-insure employer, which requires prior approval from the Workers' Compensation, Commission. An employer who wishes to self-insure must receive approval from the Workers' Compensation Commission for self-insurance plan of the employer or government self-insurance group. And if the commission denies the use of a self-insurance plan, the employer may apply to the commission for approval for another self-insurance plan. To simplify all of that, you have one or two options. You either go through some common companies, such as the Chesapeake Employers Insurance Company or other insurance companies that like Travelers or other type of major insurance companies, or you can create your own plan. And that plan has to be approved by a commission, and you go back and forth. If they deny it the first time, you can do it again. You can keep trying until they eventually accept your plan. Simplest way. So next, there, excuse me, for employers, I'm sure a lot of you are asking, well, why should you get compensation? Why should you get workers' compensation insurance? Well, for starters, it's required. As I mentioned earlier, since any business with one or more full-time or part-time employers must have it, then you have to get workers' compensation. Secondly, it protects your employers. So any type of injuries that they occur during the job are covered, from medical expenses to lost wages, rehabilitation, all of this is covered under workers' compensation. And then lastly, it protects your business. For workers' compensation claims, any workers' compensation claims, employers automatically waive their right to sue their employers. Excuse me, employees waive their right to sue their employers. So from that standpoint, you're legally okay for most situations. Of course, there's exceptions, but uh, simple and plain, workers' compensation is beneficial to the employer as well as the employee. So one of the common examples of where workers' compensation can be a little bit complicated or very complicated, depending on how you look at it, is travel. So unless an employee is on a personal errand that is unrelated to their work, injuries to traveling employees generally is compensable as long as the travel was required by the employer. So simple and plain, if the employee wouldn't have been there unless the employer required them to be there. Normally, injuries that occur during that time period that are related to their job normally are covered. So there are exceptions to this rule, though. One of them is the coming and going rule. And the coming and going rule is pretty simple. An employee is responsible for getting to their job and coming home or going wherever else. Once again, coming and going. So any injuries that occurred during that time period normally are not compensable. Simple and plain, how the courts have put that is an employee is expected to be at their job. So for an employer to always be on the hook for an employee's travel, then essentially there would be a wide list of cases and circumstances where an employer would be liable, so much so that it just wouldn't be reasonable. A great example of this is Morris versus the Board of Education, Prince George's County, 1995 case, classic case to exemplify the coming and going rule. Morris was an educator for special ed students who travel from home to basically teach them. One day on her travel towards one of her appointments, she got into a car accident and tragically passed. The courts did not give her did not allow her to sue her employers. She probably did get workers' compensation, but she was not allowed to sue her employers because of the fact that she was supposed to be there. That was a part of her job, was traveling from her home to whatever her site of duty was. Now, an exception to travel cases is the potential risk test, which is an injury that arises out of employment if it would not have occurred if the employer's job had not required the employee to be at the place where the employee was injured. This goes back to what I said earlier. Difference between Morris's case and these cases that I'll highlight is the fact that Morris could have taken a lot of ways to get to her job. That you can't hold the employer liable for all of them. But if you are limited to an exact way that you have to travel, let's say you have to travel by plane or by train, or you can only park your work vehicle at this place, this is where the employer becomes liable. So another Prince George's County case, Prince George's County versus Zoom. Zoom was a police officer who worked in Prince George's County, but he lived in Montgomery County. but he was required to park his police vehicle at a church prior to going to work and prior to coming home. So it was kind of his in between spot. So on his way going to drop off his car, he got into a serious car accident, and he sued his employers, and he won. The reason why he won is, once again, if it wasn't for the employer, would he have been at that church? No. Another case, a firefighter, Roberts versus Montgomery County. A firefighter who was leaving a training session going to pick up his mail was injured in a car accident. The court also ruled in his favor for the exact same reason. If it wasn't for him having to go between the training session to his mailbox or to pick up his mail, then he wouldn't have gotten injured. Essentially, he could have picked up his mail anywhere, but his employer required him to pick up his mail and to always be consistent with his mail at the fire department. So it was still in line with his job. Something to make it easier for a lot of farmers or producers is, imagine a situation where you have a pickup. If you have some type of item that you need your employers, or you should your employees to pick up, and they come from your farming operation to wherever this place is, and in between there they get into a car accident. Yes, you can be liable in certain circumstances. If that employee is coming from your job to the place where you're requiring them to be, then there can be some type of liability. But once again, LEI, we are not giving legal advice. We're just giving the information that we research from our cases. So, what are some of the employer's obligations when there is an injury present? So, if the employee misses more than 3 days of work due to an accidental personal injury that causes disability, the employer has to file an accident report within the Workers' Compensation Commission within 10 days of learning of the accident. So if the accident happens while an employer is on vacation, they're away from the site and they come back and then all of a sudden someone's not there. When they learn of that incident, they have 10 days to report that incident to the commission. If the employer learns or receives notice that an employer has been disabled due to occupational injury, the employer must promptly report the disability to a commission. So still, it's probably within that 10-day window. There isn't necessarily as concrete of a time period as the 10 days, but generally as quickly as possible would be preferred. Now, that's what the employer's obligations are when they learn of the injury. Now, the employee also has to file a claim to the commission. So injured employees first must tell their employee about the injury, either orally or written within 10 days of the injury. If the employee dies because of the injury, the family must notify the employer within 30 days. And if the employee develops a disease, the employee or employee's family has 1 year from the time the disease is discovered to tell the employer. After the employer is notified in writing, the employee still has more steps. They must state their name and address, note the time, place, and nature and cause of injury, and sign or have someone sign if they are disabled or of serious injury on their behalf, the document, the file. If the employee died as a result of the injury, the writing must be signed by at least one of the employee's dependents or by someone else on their behalf. After that, the employee must file an employee claim form, C1, and physician's report, if available. If you can complete the form online or request to print the form from the Workers' Compensation Commission. For most accidental injuries not ending in death, employees have 60 days to file a claim. For an accident ending in death, the employer's family has 18 months to file an employee's claim. And if the case is of a pulmonary dust disease, the employer's family has 3 years to file a claim. So once again, example of that is asbestos. So hearings. Either the employer or employee may request a hearing to investigate a claim. The hearing may involve witnesses and medical examination of the employee to determine the severity of injury. A member of the state's Workers' Compensation Commission holds the hearing. The Workers' Compensation Commission is a 10-member board of attorneys appointed by the governor. The Workers' Compensation Commission will make or deny a claim within 30 days of mailing of the notice of the filing of the claim or hearing. If either the employer or employee is unhappy with the commission's decision, Either may appeal to a circuit court. An appeal must be filed within 30 days of the commission's order. So, in plain, after a hearing, either party can appeal the decision to a court, but the commission is the first, I guess you could say, legal body to hear, uh, and try your case before. So, attorney fees. Employees have a right to be represented by an attorney. However, attorneys cannot charge a fee until it is awarded by order of the commission. Any fee will be a percentage of the award made by the commission. So there's no reason as an employee or employer to be nervous about going into to having an appeal. So, can you receive funds if your employer doesn't have insurance? Yes. The Uninsured Employers Fund purpose is to protect injured workers whose employers fail either willfully or negligently to carry workers' compensation. The fund is responsible for paying workers' compensation awards, including medical payments, and to claimants who fail to receive payments from their employers who do not have compensation. And that's all I have for you all. Here's a list of resources that I mentioned throughout the presentation. Maryland Workers' Compensation Commission, which is the commission that hears a lot of workers' comp claims, the Uninsured Employers Fund, and Maryland's Law Library, where you can get all the information you need for workers' compensation. But also, you can come to ALEI and our website, where we will have once again, we have a list of legal resources that we are giving to our shareholders to provide them with the information they need. So thank you all and have a great day.